Hey guys, Law and Crime is reporting at the last status conference for Sarah Boone. The judge moved the case out to April to accommodate defense time to prepare as well as trial schedule. And also, apparently, defense gave notice they would use battered spouse syndrome as a defense in the case. Well, that's news. She's going to go with self-defense. So her original story to the police, of course, was first to start off, I don't really know what happened. And then secondly, it became, we were just playing hide and seek, bro. We were just playing hide and seek, and I went upstairs and fell asleep. I never wanted to hurt this guy. This is just a terrible accident. But it appears now that they're going to pursue a self-defense angle, that she was battered, and therefore it was reasonable for her to kill this guy. There's a lot of inconsistency in there to me right off the bat. If you're mad about this, I would stow the anger. Everybody's reaction to everything all the time is just to get mad about it, and more try to understand what they're talking about and whether that really moves the needle for her or not. I don't, off the top of my head, I don't think it does. Although you got to come up with something, because her original stories to law enforcement that this was an accident, that we were just playing a game. I went to sleep upstairs and all that. And she seemed to focus in her interrogation or discussion with the police on it wasn't intentional. She kept saying it wasn't intentional. And I think, her street lawyering at that time was that takes the wind out of the sails of the prosecution if you didn't intentionally kill the person. But it's not true, because if she intentionally committed the acts that would have let a reasonable person know that you're going to kill this person or you're likely to kill this person, that's just as good. You're just as guilty. She didn't understand that. So the mouth running she did was terrible. She should have shut the hell up for her sake and get a lawyer. And then they could have come up with a self-defense thing right off the bat, instead of making what I think are going to be contradictory remarks to that as she proposes a self-defense theory. To pivot to self-defense, they're going to have to paper over the inconsistency with her original story of we were just playing hide and seek. I mean, that's what grown people do, right? Especially in suitcases. And then they go to sleep while they're doing it. Yeah, that all makes a lot of sense. She's got to move that to, well, if you were in fear for your life of this guy so much so that it was reasonable for you to kill him, then why didn't you tell us that? And of course, they'll go with the whole, well, I thought the system would mistreat me. I was traumatized. I'm PTSD. I didn't even know myself exactly what was going on. Although I certainly knew that, that I was in fear for my life. I just didn't want to tell you that. I don't know. They'll have to come up with something on this. So we'll leave behind the allegation of the hide and seek stuff, because we've already talked about that. We'll imagine that there's some scenario where they try and paper over, make help her pivot from that over to the self-defense, and talk about whether we should immediately be outraged that there's this battered spouse syndrome defense. And I don't think, to me, that the battered spouse defense causes more anger than any other nonsense self-defense claim. Either she has the facts to back it up or she doesn't. And I'll explain why I think it is a legitimate thing to have in the law. But first, let's talk about Florida's law for use of deadly force and claiming self-defense, because battered spouse syndrome is not a special defense, really. It's an element of establishing self-defense. So what would be applicable in this case is this law. A person is justified in using or threatening to use deadly force if he or she reasonably believes that using or threatening that is necessary to prevent imminent death or great bodily harm. And a lot of these cases turn on whether there is a reasonable belief that you're about to be killed or seriously injured. That's really what it is. So if the person's running away from you and you shoot him in the back and you're trying to claim self-defense, this is the part that's going to trip you up. A person who uses or threatens to use deadly force in accordance with the subsection does not have a duty to retreat, and they can stand their ground. Of course, that's been in the media as some awful thing or whatever. But it didn't change the law as much as the media tried to make it out to be. It's just more, let's all be mad about something all the time. In fact, to my mind, Florida law was way worse in the past. While this new stand your ground thing is not some special boon for domestic violence victims, the old law was terrible for them. The old law basically was that you had a duty to retreat, even in your own home. So, and also if the person lived with you, even after they said, well, we don't think it should be that way. If the person had an equal right to be there, the idea was you needed to leave. So if you were the woman being beaten or whatever, and you finally responded to that, but you could have figured out a way out of the house, then the law says, well, you should have done that. And that pretty much precluded this whole threat, I'm going to kill you if you leave, and beating the person to within an inch of their life, and then telling them, if you leave, I'll finish the job. and the person's so terrified they don't leave, well, the law said, no, you got to leave. But they ended up changing that, and they said, no, you don't have a duty to retreat out of your own home, even if the person attacking you is someone else who lives there. That's fair, isn't it? Isn't that fair? So this whole battered spouse syndrome, of course, we used to know it as battered woman syndrome. That was never a good term for it, I think, in terms of woman, because it could be either person, male or female, and syndrome, because syndrome implies something there that I don't think is really necessary for this. The idea is that, obviously, let's say I'm walking down the street and somebody pulls a gun on me and says, give me all your money or I'm going to shoot you, and I'm going to shoot you anyway. I'm going to tie you up and kill you, and I manage to outdraw the dude and shoot him first, then I've got a good case for self-defense because that's imminent harm. And in a lot of states, Florida is one of them, and North Carolina too, there's this presumption that if somebody's breaking into your house and you shoot them while they're breaking into it, they're going to presume that you had this fear of imminent threat of bodily harm or death. So that's always, or not always, that's mostly always the turning point for these kind of cases. So the question is, how do you deal with a woman who shoots a guy? The idea being that she's not at that moment being beaten to a point where she might die. How do you deal with that? And it could be the other way around. It could be two men or whatever. I'm going to stick with the old school scenario of the battered woman, even though it applies across different things now. And it also, it's battered spouse, but it covers live-in people too. I mean, come on, people, let's all be modern here. So some of these terms haven't caught up with even the reality of how far the law has evolved on it. But sticking with the theory here, let's say there's an extremely abusive relationship. The person is beaten repeatedly and traumatized and threatened, because sometimes it is true. If you walk out that door and leave me, I will hunt you down and kill you. That does happen. These threats can be very credible. And a domestic violence order can be obtained, but the threat can be, I'll kill you if you get that. And that happens too sometimes. So the concept is, can an abuser who is beating someone and making them in fear for their life over a period of time create in the abused person a mindset that the threat of death or bodily harm is imminent to me now, even though the person doesn't have the gun pointing it in my face? They have told me in a credible way, I will beat you again, and if you leave, I will kill you. Are you in reasonable fear then of imminent death and bodily harm? And that's kind of what this battered spouse syndrome is about. So that means Sarah Boone would have a lot of work to do to come up with that one. I mean, she doesn't have a duty to retreat. If she could show the guy and be beating her with a hammer, and she tripped him and he fell into the suitcase and she managed to zip it up and he's in there yelling, the moment I get out, I'll kill you. That would obviously be a better case for it. Or if he had been seriously injuring her in the past, which she has said that he has done, although I think we know that she's given it back to him in some. She's still got a long way to go to show that the reasonable thing for me to do was to leave him zipped up in that suitcase to kill him because of the terror that I had that I couldn't leave. I hadn't heard, at least from her, that he said, if you leave, I'll kill you. Has he ever said that? They may come up with that now, but I hadn't heard that before. Or that he was beating her so regularly and it was such a dominating relationship that she felt that she had no power in it and that her life was essentially forfeit. I mean, does she have the facts to back that up? She's closer to that than she is to the idea of saying, well, it wasn't intentional, so let me go, because that's nowhere. This one will require a lot of mental work on her part. She does love seeing herself as a victim. So she's going to love this kind of defense where she gets to talk about how bad he was and how much suffering she did. And every time he hit her, it was terrible. Every time she hit him, it was okay. She's going to do all of that. That doesn't mean any jury is going to buy it, right? So I think there are cases where the degree of abuse and pattern of abuse is significant enough that a person could be left with the only ray of hope they see, the only way to live through this without being hunted down and finished off after having been beaten and treated without mercy over a length of time, is to kill the person in a moment where you think you can do it, even if that's sleeping. Is that a rare case? Absolutely, it's a rare case. But a long time ago, there used to be the idea, at least in some lawyers' heads, especially in the West, maybe somewhat in the South, that sometimes there's he just needed killing defense that isn't on the books anywhere, But you could look at a person and go, the world's a better place without this person. And to me, that's a little bit how I kind of old school look at these cases. Was that person so terrible that they so dominated this person's life with pain and misery and fear that at every moment that person was in imminent fear of either serious bodily harm or death? I think that can happen. But that's where you get the expert testimony, because you have to show that it did happen to this person, that the things triggered this, that a reasonable person in her position would have felt this way. So she can't come to court and say, well, he hit me once, or, we had a fight and therefore I can put him in a suitcase and zip him up. I mean, I don't think this defense works in her case unless there are a lot of facts that we don't know about. I don't think it's a defense, though, that is illegitimate in its totality, because there are circumstances where it should apply. Does it apply all the time now and everybody's getting shot and killed under it? No, I don't think so. I mean, could it be abused sometimes? Yeah, probably. But I don't think it's going to work here. They have the videos of her laughing at the guy while he's in the suitcase dying. That looks very terrible for her. She doesn't sound like she's terrified. She sounds like they go back and forth on this stuff. And if it's true that she thought, well, he'll get out, I left a hole for him to get out, that doesn't show that she's in imminent fear of anything. Remember, she told the police, I didn't zip it up all the way. I thought he would just get out. So if you were in fear of this guy, that what he would do to you later, why would you make him angrier by zipping him up in it and not letting him out when he wants to get out, even if you thought he could get out, because he's just going to be madder. So I think this is a new defense that her lawyer has come up with. The things she said before are the opposite of that. She's got to find some way to try and get past what she said before, and then a new set of behaviors. So in my mind, it's a valid form of defense to engage self-defense. I don't think her facts fit into it any more than most other murders that occurred, and she'll find justice at the end of this. But maybe she'll stop writing letters to the judge, because she has a lawyer who's going to let her play the victim card, and maybe her case will finally get tried, and that will be that, and it'll be an open and shut case. Thanks, bye.